Good morning, good afternoon, good evening, everyone. It's my great pleasure to open this webinar in the capacity of an organizer alongside with Daniel Brantes Ferreira from CBMA, and to say hello to this stellar lineup of experts that will enlighten us on this new regulations of mediation in FIFA. So in order not to take, the best possible advantage of our time, I just would like to thank Faraz Shalai very much. So I know him for a long time, and I can testify that his value as one of the most important experts in this area. Also, I would like to thank very much Jeffrey, Erica, Roberto, right? And last but not least, our president, CBMA president, Gustavo Schmidt, and all the crew that is, behind the scenes making this webinar possible. So without further ado, my dear friend, Faraz Shalai, you are our moderator, so you please take the stage and enlighten us with your words of wisdom.
Thank you so much. Hello, everyone, and thank you for being here in our webinar on mediation in FIFA. My name is Faraz Shalai, and I'll be the moderator for this panel. Today, we are honored to have both participants and speakers from all over the world joining us today to learn more about the role of mediation in resolving disputes within FIFA. As we embark on this informative discussion, I would like to encourage all our participants to actively engage and share their thoughts and questions with the panel. We will have half an hour at the end to go through the questions that everyone might have. We have an esteemed panel of experts today who will be sharing their experience and insights with us today. So first we will have Erica Montemor Ferreira. Erica is a Brazilian lawyer specialized in sports law. She has worked as a lawyer in Brazil and Spain. She has dealt with disciplinary and financial fair play matters in UEFA and is currently the head of the FIFA Players Status Department, responsible for the resolution of the contractual disputes, training, compensation, eligibility, international transfer related matters, and protection of minors. Erica will walk us through the background, the history, and probably why FIFA has created these mediation procedure for resolving the disputes. Next, we will have Jeffrey Benz. Jeff is a dual qualified English barrister and US attorney, as well as a sought-after ADR practitioner with jams based in London and Los Angeles. Following a career as a litigator with a large international law firm, Mr. Benz worked in-house at global sports, entertainment, and technology entities, including in executive leadership positions. Since 2001, Jeff has mediated and arbitrated several hundred complex domestic and cross-border disputes. And finally, we will have Roberto de Palma Barraco, which is an attorney, mediator, and arbitrator focused on the lifestyle industries, especially sports, art, entertainment, fashion, and food. He is a leading conflict management and crisis prevention consultant on the lifestyle industries. Roberto's transnational academic background is the basis of his work. His immersion in different cultures makes him a translator of legal cultures. We'll start with Erica, and we'll get more information about the history, the background, and why FIFA came up with this mediation procedure. Erica, the floor is yours.
Thank you, Faraz. First of all, I would like to thank you personally for the invitation to be part of the webinar today. And obviously it's great, even though it's online. I prefer to be in person. I miss these guys. That I'm also lucky to be long enough in the industry to have good friends, which include Jeff and Roberto. And actually, they are the experts to talk to you about mediation, but I will walk you through what FIFA has done so far with their support. And it is indeed a very exciting project that we are leading in FIFA within the player status department. So I'm going to share my screen just to make a bit more visual. Does everybody sees that, right? It's working. Okay. So start, as you know, first of all, in player status department, one of our biggest competence is contractual disputes. So contractual disputes involving players, coaches, clubs, and national associations with an international dimension. And the volume of cases we have in this area is quite big. It's more than 2,000 cases per year. They are submitted and decided by the Football Tribunal. And FIFA has the dispute resolution system for more than 2 decades, right? And so as you said before, I'm in FIFA, but I was in FIFA before I went to UEFA, actually. So I have 2 lives in FIFA. And I like to do that comparison also to say how much it changed and how much is much more modern now in the dispute resolution system. And that's a bit the reason why mediation came into place. So first of all, when I'm back in FIFA in 2019, that's when I become head of player status department. And we started within the vision of the president to modernize the regulatory framework, start to review the complete system. So before the deciding bodies were being created as needed. So first we had the player status committee back then to deal with the contractual disputes between clubs, which were the first kind of disputes that were brought to our deciding bodies. But then in time, obviously, because of many of the employment-related disputes, the dispute resolution chamber was created. And then after that, because we also have the competence of regulatory applications, such as the transfer of minors, the protection of minors, then we also had the subcommittee of the player status committee to deal with all the more than 10,000 per year transfer and registration of minor players. And so as you saw, this was being developed, but they were like creating the different deciding bodies without an actual, to be concise and being modernized. And so when I come back and we see also the backlog that we had at the moment, there were more than 1,500 cases pending. There was a huge delay. We're not very efficient. There are lots of problems. And so we decided to really see the whole process, be more efficient, review the internal processes, and also review the deciding bodies. And so in October 2021, they created the Football Tribunal, so creating one single tribunal with different chambers to deal with the different competences. And so we have the player status chamber, the dispute resolution chamber, and in October we'll have also the agents chamber, which will be created in accordance with the new regulations. This is not under my competence, but just to give you a complete overview. And in this sense, also new regulations were created, new procedural rules were created specifically to the Football Tribunal. And at that moment in time, we were also trying to see many ways of being modern or finding alternative ways to deal with this workload. And so the first thing before mediation even was actually proposals. So using that administration see in straightforward cases of outstanding remunerations, instead of going through a whole proceedings, that we could use proposals coming from the FIFA administration for the parties to find a solution without having to submit a case for a decision. And this was very successful. But we also saw that this was only for very straightforward cases, but this could not be suitable for cases where they were complex or there were more than 2 parties. Or maybe there was a breach of contract, and then really we saw the proposals. First of all, we could not, according to the rules, and also they would probably not be effective. So when we created the new Football Tribunal and redraft the complete set of procedural rules, we introduced at the moment Article 26 that you see on the screen, which says that the chairperson of the Football Tribunal, if he considers appropriate, it might invite the parties to mediate a dispute. And here you might ask, but why it has to be an invitation? Why it cannot be whenever the parties want? Also, because from our experiences, what we don't want is for parties to use mediation to delay a decision or to delay, the obligations according to the contract. So actually, the idea is the mediation is only if we consider it is appropriate. Obviously, our experience, if the parties ask for it and we see it's genuinely they want to find to use mediation as a way to settle the dispute, that will also be a possibility. But in principle, is, let's say, by invitation, when we realize that there's there's such a complexity that we deem that the mediation is the right to be used by the parties to find a solution. We put an example. Usually a breach of contract where you have the former club player and a new club. And many times there's a claim and a counterclaim, and it's quite a complex scenario. And you also have the possibility of being sanctioned, not only the financial consequences, but also the sporting sanctions. And therefore we think that this is, for example, one of kind of case that is definitely worth going to mediation. You can also have cases like we had the Sala case, for example. It wasn't in mediation because mediation was not in place. But these are some cases that perhaps the simple regulations cannot answer. And we do think that relying on very experienced mediators like Jeff and Roberto and all the ones in our list is the right way forward. As you can see, it's a voluntary process and it's free of charge. So it's the same as all the employment-related disputes, is a free service given by FIFA to the football stakeholders. And first, it was just making reference to the CAS mediation rules, but then we actually decided to create our own rules and guidelines, literally using the experience of the mediators. So the first thing we did was to do a workshop. So first of all, just to go back a bit, when we created the mediation, there was a circular letter inviting members, mediators, experienced mediators in the field to apply. They applied, and then we came up with a list of the FIFA mediators. We did a first workshop, and basically we actually reach out to them to ask for their expertise, for their experience, for documents, for everything that we could use to then create the guidelines, obviously within the scope of the Football Tribunal and the FIFA regulations. So here, just very short to say that, so first, in a normal case, what happens is that we receive the claim, and there's a first analysis of the claim, because also we receive many times claims they're either time barred or they're really parties that cannot be parties before FIFA, like a company, or that is actually a subject matter that is not within the FIFA regulation. So we do this first analysis. Then we do the exchange of submissions between the parties. And that's the point when we have a complete overview and we invite the parties to mediate. And if they do accept to do so, then they sign a mediation agreement and the start of mediation will begin. And if it's successful and there's actually a settlement agreement concluded between the parties, then this settlement agreement will be ratified by the Football Tribunal. I'll explain a bit more in a second. So as I said, I'll divide in 3 stages. So for the first stage is like the pre-mediation. As I said, we're going to first have a look and check whether indeed the Football Tribunal has jurisdiction, competence, and the claim of the claimant is admissible. Then we will invite them to mediate. And here is, if they accept so, there's a nomination of the mediator. And here, actually, in theory, is the parties that should mutually agree on the mediator from the FIFA list. But if they don't, if they cannot find an agreement, then FIFA can nominate the mediator. The second stage from then, so the mediator is appointed, and from that moment on, the mediator takes over. So this is also very important for parties to understand that FIFA and the FIFA administration is not part of any of the meetings. So as soon as parties agree on the mediation, then the mediator will take over. They shall sign the mediation agreement and send to FIFA. And then the parties will be provided instructions on how to mediate, and everything will be conducted by the mediator, as I said. The only thing that FIFA needs to know is if there is at the end a mediation or not, because obviously if the mediation is not successful, the case will continue and be submitted for a decision. But if there is a mediation, then a settlement agreement must be concluded. And here it's important that the party shall sign a settlement agreement. And yes, it needs to be sent for FIFA for ratification. And why is that important? Because another thing that is important and very dear for our dispute resolution system is the fact that the parties can execute the decisions within the sports world. So you don't need to go anywhere else to execute a decision. Simply, if the party does not comply with the decision, sporting sanctions will be imposed and is immediately in the decision. So nowadays, our decisions don't even go to disciplinary. It's simply already in the decision, it says this party needs to pay this amount. And if the amount is not paid, then these are the consequences for the non-fulfillment of the decision. And for that reason, we need a settlement agreement, because this settlement agreement is also similar to a decision, and it can also be enforced via the system. And that's a bit the reasoning why we need to make sure that we have the settlement agreement. Just a few more topics before I pass on to the actual experts in the house. So as I said, competence and jurisdiction already touched, enforcement. It's a key point, because again, we're trying to be efficient and not create another case to then be again submitted for a decision and so on. So it's really using the mediation to solve disputes in a very efficient way. Confidentiality, obviously the settlement agreement is confidential. We will receive a copy because this is going to be enforced and rectified, but it is confidential to the outside world. Another important part is, in principle, no partial settlements. I'm sure Jeff and Roberto might have a different opinion, but what we said, at least in the beginning, is the idea is if there is a claim, there should be a settlement for the entire claim, because otherwise you're mediating that part, but then you're creating another dispute to be also solved for the football tribunal. Regarding state of proceedings, in principle, the proceedings continue. Obviously, you're not going to pass a decision while mediation is happening, but it's to say that we're not going to stop everything, because you don't want parties to use mediation as a tool to stall their obligations. And finally, as I said, the ratification is important, so the parties can then enforce that settlement agreement within the system. I think that's about it for now, but I'll leave up for questions for later. And just to say that it has been a very successful so far. I was actually surprised. I'm going to be very honest. In the beginning, I felt when the project came to the idea came, we said, I'm not sure parties will do that, because they're used to, we were used to be very slow and things would take a very long time. So they will use the system to delay their obligations. Now is a different story. And I was a bit skeptical whether parties and lawyers will, really go for the mediation. But so far, the experience has been very positive. And I really think it's very unique, even if I compare to the proposals, because you really create this thing where the parties find a solution and to also keep intact their relationship, right? And also avoid the imposition of sporting sanctions. So I really think it's very positive. Thank you very much, guys. Back to you, and I'll stop sharing my my screen.
Thank you so much, Erica, for sharing your experience. I know that you have been instrumental in this process, and thanks for all you did and all you're doing. Next, we'll hear from Jeff, a CAS arbitrator, a CAS mediator, and a FIFA-approved mediator, that we will hear from him about some practical challenges in these proceedings and how these proceedings will work. Jeff, take it away, please.
Thank you, Faraz, and thank you to CBMA and Loyola Law School for having me here and for assembling this great group of people. As you get older in your practice and experience, you have the great pleasure of being able to suddenly serve on panels with lots of people over time. Maybe that's an indication of impending retirement or something else, but who knows? But I do have the great benefit of having known Faraz as a student in my class at Pepperdine Law School, where I often asked him, how are you going to make money doing human rights in sports? And him telling me, I just don't understand. And now he's doing a JSD in human rights in sports. So more power to him for thwarting the efforts of a commercially intensely minded adjunct professor to take him off his track and to keep going. I've obviously had the good fortune to be around Erica in a variety of different formats. And I have to say that for FIFA to take this mantle on is a very unique thing in my experience across all of international sports. I mean, FIFA has really suddenly embraced mediation, and Erica has been driving its implementation, asking the questions, but what about this and what about that? And you have a view on this and other people have a view on that. And what do we do? And how do we get it done? And it's now across the line. There is a program out there, and you don't find it implemented in this way in any other international sports federation in the world that I'm aware of. And hopefully the rest of them will wake up to see the promise and benefit of mediation, and will be willing to stick their toe in the water of trying it out and making it better and seeing how it works. Roberto, I've had the good fortune of knowing a number of years. I promised him that I would make some comment about the idea of food disputes. I don't know what that's about. Maybe that's about different types of barbecue flavor that you like or don't like, or something like that. I can only imagine what that will be like over a beer someday somewhere else in the world. And for those of you out there that do commercial cases, if you have not done a food supply case, you have not lived to know about very disgusting things that go on in providing food to the world, and things, and the tolerance levels for errors and bad things that go on. So I leave that for a different webinar. I have done a number of those cases, and believe me, like, I don't eat eggs the same way anymore, or chicken or other things. But having said that, I'm sure Roberto will get back to me when he follows up with me. I think that you see partially why FIFA did this, right? I mean, Erica made the case for it. They have thousands of cases, thousands of disputes, and a docket that was not capable necessarily of resolving those things promptly or quickly. I mean, a docket of 2,000 disputes is double the docket of CAS, or more than double the docket of CAS, at around 900 annual arbitration cases. And that's significant. And that's typically when jurisdictions succumb to the idea of, we've got to do this faster and better. And so in the US, in the 1980s and 90s, mediation had its rise and its heyday because of docket congestion and the like. And it's now heavily practiced, so that, about 95% of cases in the US never see a courtroom. They all get resolved before they get to a trial of any kind. And it's a natural process that way. I think that I've come up with some alliterative terms that all begin with the letter F to describe the FIFA process. So beginning with FIFA, I would say that fair, flexible, fast, and free are the main selling points. And Erica, you might want to write that down and put that in your marketing materials. But I think that at the end of the day, the parties see no expense from engaging in this, aside from a little bit of time and effort. And they end up with the opportunity to have very flexible outcomes that can be crafted by them and their mediator to achieve something that might actually restore peace between the parties, so they can continue in a business relationship going forward, or at least get rid of the problem that's currently in front of them. And when I say flexible, it's not necessarily strictly bound by rules. Yes, you will be bound to make your settlement fall within the confines of what the FIFA regulations say is permissible or not permissible. But beyond that, the sky's a bit of the limit there. It's not like you're presenting to an arbitrator who's going to rule for you one way or the other. And I think that it's relatively fast. It takes a very quick process to do a mediation session. The parties need to have enough information about their position and the other side's position to be able to figure out, what's this going to look like if I have a bad day in the actual decision process. But at the end of the day, mediation can be done relatively quickly. So you have maybe a process, and I'll talk a little bit about this, an approach that involves a private phone call with the mediator and then a mediation session. It's pretty much left up to the mediator to craft the process that they think works the best for the process within the FIFA program. And so you'll find differences of approach from mediators based on their cultural backgrounds. You'll find differences of approach based on where they're from in one country even. So in the United States, the West Coast approach is to caucus everybody separately all the time, on the idea that you don't want people coming into the room together and constantly pulling that Band-Aid off of the issue that's made them fight with each other all day long. And other places in the US are more open to people coming together and being in the same room together and having an open and frank discussion. Different approaches. They can all get to a settlement in some way or the other. But if you want to engage in mediation with a mediator, you should pick the process that you think works best for your client or for you or for your approach as a lawyer in the process, what you think gets you the best result. And I think that you also have different approaches to mediation based on the legal tradition that you come from. So if you come from a common law jurisdiction, my experience is it's a different approach than from a civil law tradition. Brazil seems to be a little more open to mediation than some other civil law jurisdictions. Italy is crazy about mediation. But if you want to be a mediator in Switzerland, and hopefully none of those Swiss people are on the phone here, I hope you have a second job or something, because it's a rare experience to be a mediator full-time in places like Switzerland and France and Germany and things like that. Although the world as a whole is coming around to mediation as a viable approach to quickly, efficiently, and flexibly resolve disputes in a way that's it's not time consuming. It can be not time consuming. A one-day session with me is a lot cheaper for you, and certainly in the FIFA system, since it's free for you, than it is for you to go into a multi-day hearing to take on these issues. And I think that one of the things I find sort of very progressive about this is that FIFA is ready to take this issue up early. So by the time the disputes get through the internal FIFA process and you have a full-blown arbitration process in front of CAS, the parties have fought at least twice before. They're sick of each other. They're sick of the case. They're sick of their positions. Probably they're sick of their lawyers, or at least they're sick of paying their legal fees. And they're entrenched, and they want justice, and they want to win, and they've briefed everything, and everything's a sunk cost, and expenses are all in. If you can nip that process in the bud, as they say, earlier, and get to a mediation process earlier, like this process offers with cases that come out from FIFA, you're able to, I think, have a more impactful result as lawyers, as mediators, and as clients. You get the ability to change your future in a better way. And the CAS timing issue makes it very late in the process, and it's more difficult. I do CAS mediation cases, and the parties come to me in a procedural position that's very similar to what I just described, if they've been through an internal process. And it's a different animal altogether. And then, having said that, I think that I would just stop by saying, be open to the process, no matter the cultural or legal tradition you come from with respect to mediation. Try it out. It's not magical pixie fairy dust. It's a process that, once you're into it, lends itself to pulling you and pulling the parties together to a point where they can at least say, hopefully, yes, we can walk away from this and hold our head high enough, if not high all the way, and be happy with the outcome. Now, I do say, and I say it to everybody that's appeared in front of me for mediation, that I'm in the business of mutual dissatisfaction. So if you could solve your case on your own, you wouldn't come to me. You'd be completely satisfied, and that'd be great. But when you come to me, my best day is to make you unhappy, but unhappy just enough that you'll agree to an agreement, and unhappy for the other side just enough that they'll come to an agreement, and you'll resolve your case. And maybe a few days later, you'll say, okay, that Benz guy was okay. Yeah, we were a little unhappy when we left, but we settled the case. We've moved on. We're together in business again, or we are apart and happy that we've gotten out of this problem and we're moving on. So I would say keep that in mind. I'm happy to answer any more specific questions than that. And I will turn the floor back to Firas. Thank you.
Thank you very much, Jeff, for sharing your great insight on how this process might work, about different approaches that might be there, facilitative, evaluative, or those type of transformational, and those type of approaches in mediation that we have. But we'll next hear from Roberto Barraco, an attorney in Brazil with an interesting background in dispute resolution, and he will be discussing some aspects of the enforcement of mediation agreements and some cultural challenges that might arise during the process. Roberto, the floor is yours.
Hi everyone, it's a pleasure being here today. Well, I'd say that I first have exposure to make. Jeff is the expert. I'm basically his trainee, so there's that. Well, other than that, it's definitely a pleasure being here. I was telling Erica early on today, my heart is basically pounding in my chest, so it's a real challenge to speak after, I'd say, my professional role model, not to say my person, also role model, and also my go-to person in this resolution. So I'm talking about Erica and Jeff. It's definitely hard for me to be here at CBMA. I was telling Danielle that it's not only a pleasure being here, but it's also brings me some really fond memories. And I would like to thank Jair and Danielle for the invitation. And definitely for us, it's definitely a pleasure being here today. We had a really wonderful conversation before. And I'd say that talking for about 10 minutes, it's next to impossible for me. I tend to speak a lot less than that usually. So shall see how I go. And I'd say that I have two main questions that I would like to try to answer or give some possible answers. One is regarding why is mediation helpful in the end? And the second one is how do we do it? Or at least the Brazilian way. And why is it helpful? It usually, and again, Jeff is the guy, when we're talking about mediation, we have a real challenge when we're talking about transnational mediation, simply because Singapore Convention is nowhere to be found, especially in Latin American countries. So it's tough to enforce a decision unless you go through arbitration afterwards, or you have some other mechanism in order to make it more enforceable. If we're talking about a national mediation place in Brazil, then it's easy, but when we're talking about a mediation based in Zurich at FIFA, then it's a little bit trickier. And FIFA really went a really interesting way, and I am totally 100% with Erica and Jeff on that front, in the sense that it's easier to enforce the mediation agreement associatively. So basically, given the possibility to the parties to ask or request sporting sanctions, that is super cost effective, or at least has the potential to be cost effective, in the sense that you don't have to go through arbitration after all, or you don't have to go through the national court in order to enforce the decision if one of the parties decide not to go through with whatever the parties agreed during the mediation. And I'd say that that also tackles one of the main challenges we have when we talk about why mediation can be helpful. Because usually when we are talking in Latin American countries, one of the caveats we have regarding mediation is that usually we tend to think that the parties are never gonna honor the agreement that they themselves agreed upon during the mediation. And when we have sporting sanctions available, it makes it a lot easier because you have something to rely upon if someone or one of the parties decide not to do what the party should have done before. That also brings some global perspective, I'd say, with this idea of sporting sanctions. I'd say that we do not have a challenge when it comes to FIFA, because FIFA basically rules soccer throughout. But if we're talking about mediation in national associations, then we would definitely have a larger issue regarding sporting sanctions if those associations would be able to enforce any mediation agreement that they would do in-house, like FIFA does, or if FIFA would be able to provide a global enforcement to those decisions. It's pretty much the same issue we have when it comes to NDRC disputes at FIFA level. So it's going to be interesting to see if a national association adopts a mediation procedure like FIFA, how it's going to play out in the future. But other than why is it helpful and the enforcement issues, I'd say that the main challenge that we have is regarding how do we do it? Because cultural challenges are definitely something to keep in mind when we're talking about mediation and dispute resolution procedures in general. But specifically when it comes to mediation, and Jeff was, again, super precise when he was talking about civil law countries, is that we generally tend to think that we have mediation and we have conciliation, and both are totally different ideas, not to mention the word that was in my mind. And when we are talking about mediation itself, at least when we are taught about mediation in civil law countries, we're taught this idea of mediation that is basically this procedure that acts pretty much like a psychologist of the parties, that helps the parties basically develop a working relationship for the future. And it's not necessarily geared towards an agreement itself. But when we think about conciliation in civil law countries, we're actually talking about trying to reach an agreement, trying to focus on the issue at hand. And when we talk about FIFA mediation, which is basically common law mediation in general, we are actually talking about how to reach an agreement, how to basically tackle the case at hand, so then the parties can do whatever they want later. In that specific cultural challenge, I'd say we have 3 potentials and 3 issues at the same time. When it comes to, I'd say, probably Latin lawyers or Latin parties, at least. One is the idea of mediation as an informal procedure, in the sense that we tend to be, I'd say, more approachable than a judge or than an arbitrator in general, or at least when we are wearing the arbitrator hat. And that might lead to some time management or engagement issues in mediation, in the sense that the parties might feel like they can stall the mediation procedure as much as possible, in the sense that it's possibly one of the challenges that mediator has when it comes to developing this culture in, I'd say, countries that have yet to have that culture of mediation. But again, it's easier to help out parties if we're able to be informal and then garner that engagement, organically speaking. So that's also an opportunity. I'd say that a second potential issue, and also something that might play out really well for mediation when it comes to the FIFA procedures, is that we are definitely not ruling the case. So we have, I'd say, more room to talk to the parties as people from the market itself, which, at least from the mediation procedures that I have seen, tend to play out a little bit easier when we are hands-on on the issue, and we can talk to the parties a little bit more freely, even if we are choosing, like Jeff mentioned, the caucus way of doing business in mediation and not a general gathering. And I'd say that a third potential issue, and also potential we have in mediation procedures at FIFA, is that although it's an agreement-focused procedures, sometimes I've seen that the expectation of the parties is actually to discuss a broader issue, not that specific procedure. And when that happens, it leads to a real challenge within the guidelines, because we have to go back to the case at hand and try to resolve the case at hand, help the parties reach an agreement on that case, while we do have to be aware of the whole context, and at sometimes help out the parties facilitate whatever they're dealing outside the procedures, in order to be able to help them agree on that specific case itself. I'd say that those are the three main issues that I see when it comes to cultural challenges that we currently face. One is time management engagement. The other one is basically how much hands-on we can be on the case, or how much the parties are comfortable for us to be hands-on the case. And the third one is dealing with potential issues that fall outside the case itself, but reflect on the case at hand. So I'd say that's it.
Well, thank you, Roberto, for your great thoughts on the matter. I really appreciate our three experts on this issue, and hope that our audience also have found this conversation helpful. We have a question from Alexander Palermo Simoes. I hope that I pronounced it correctly. It says that in a mediation procedure under FIFA new regulations, may the parties be free to choose the mediator they want, or the parties must pick a name on a FIFA's roster? So I think maybe that's an Erika's question.
Yeah. No, they need to choose a FIFA mediator, so it has to be from the list. Because first of all, obviously we learn more from them than the other way around, but it's also that we also workshops to explain to them, you know, our procedural rules, how it works, what is needed.
Oh, we lost her. Well, I would also say that the other part of it is the free part. So if you go off that list, you may not find people willing to do it. You may not find FIFA willing to pay for them. So let's leave
Exactly.
it at
that. So I think it's a mix of all this, and it's important that these mediators, they are, you know, now also understanding how our internal proceeding works, and they help us build the guidelines. And just to add one thing, it's not the question, but listening, I was actually taking notes from Jeff and Roberto, is to say as well, the reason why we decided for guidelines and not, you know, rules in the procedural rules is exactly because we do think that this is a first experience, and we will learn from this process whether there are changes to be made, or specifically because it's within football, they might, you know, need extra rules. So really, it is a work in progress, and we will count really on the experience of the mediators, obviously keeping their confidentiality, but giving us the feedback that we need to really make this a living document to be efficient. So it's not written in stone, and it's really, for us, is also a learning process.
Thank you, Erika. I want to ask a follow-up question on that one, because the guidelines say that in case of a lack of agreement between the parties to choose a mediator, the FIFA General Secretariat will nominate a mediator. It's not an appointment, but a nomination. So is it still that? It means that it's just a nomination, and the parties should agree on this nomination again. So they have to express their approval on having that mediator, or no, it's basically an appointment.
No, look, it is, because at the end of the day, what we're trying to do is make sure that the parties are open for a mediation, are open for an agreement. So I think imposing someone would not exactly be a good start. We didn't have that problem so far. So far is either the party has, or they said, no, we don't know, you can choose. And what we've been doing as well is trying to make sure we use all the mediators in our list, and everybody, you know, will have that experience. But if the parties will then oppose, say, no, we don't agree on this one, then I will give it back, right? So why don't you agree on one? Otherwise, you're going to be around in circles. But no, the idea here is not to impose, because we actually want the parties to find a settlement agreement. I don't know if Jeff or Roberto has any ideas on that one, but
no, I mean, I think the nature of mediation is not mandatory, right? So you choose to engage in it, and you should choose your mediator, somebody you're comfortable with, somebody you can live with, somebody you're willing to have a conversation with, you can build trust with, and try to move forward the discussion that results in a settlement. So I think the idea of imposing a mediator is anathema to the whole process.
Roberto, anything to add?
I totally agree with them. It's tough to impose something that should be voluntary. So at the same time, given that sports law field, especially when it comes to football tribunal, is kind of narrow in the sense of the lawyers that are there. So people tend to know each other. So I'd say that it would be next to impossible for the parties not to know at least one of the mediators well enough to trust the mediator.
Okay, thank you. And please forward me the questions from the audience, Daniel, if there are any. But in the meantime,
I have a question. May I do a question? Because obviously,
Sure.
as I said, we don't participate in the actual mediation. So my question to both Jeff and Roberto is, how is the experience with the lawyers? Because when we did the guidelines, we had in mind, obviously, the parties, but at the end of the day, we know that in our industry, most of the cases, especially the complex ones, parties will be represented by a lawyer in the sports field. So my question is, how has been the experience with the lawyers more than with the parties?
My experience in the sports field is that it's funny because they put one hat on, just like the arbitrators who are mediators do, right? You got a hat that says arbitrator across it. And just as I noticed, as I'd made a note, as Roberto pointed out, nobody's wearing a suit and a tie on this call. Nobody's dressed fancy. That's how mediation calls are. They're different. They're not the same. They're not the same formality as you find in arbitration. But the same people that will sit in front of you as an arbitrator and come in front of you as a mediator, I'm like, most of the time I'm like laughing, giggling away inside because they are embracing the informality of the mediation process compared to how they embrace the formality of the arbitration process. But at the end of the day, that you have, as a mediator, multiple audiences at a time. The ultimate audience is the client, but some clients are more or less dependent upon their lawyers for advice, outcomes, resolution of the real business issue about what's at the heart of the case and the like. So you have to, as a mediator, be sensitive to that, watching, listening, hearing what's actually being said, what's going on, watching the dynamic, if it's in person in the room or if it's virtual, how folks are dealing with each other. And you have to be willing to have frank conversations and testing conversations to try to figure that point out at times. So sometimes you might want to take the lawyer alone as a mediator, or at times you might want to say, hey, can I just talk to your client real quick about a few things? No offense to you, but I just want to see what their reaction is. And that's all technique that the flexibility of mediation allows you to do. I do think that if you're going to take the client and separate them from their lawyer, you have to use that as a rare occurrence generally, but it's something that you can do.
Roberto?
That's a really interesting question in the sense that sometimes it's a tricky answer to give. I say that, especially when it comes to a club versus a club in the football tribunal, odds are that you're going to have to deal with the lawyer alone and not the real client of the lawyer. So when it comes to that, I'd say that the toughest selling point is to prove to the lawyer, him or herself, that engagement in the mediation is useful. So it's more of, again, the time management issue. And once you're past that issue, it's pretty much straightforward. Even when you take into account different legal cultures, I'd say that lawyers in general, especially lawyers in the field, are trained to be kind of objective in the sense that if they are able to agree upon a deal, they are definitely going to go for the deal and not for the ruling of the case.
Thank you. And thanks for the question, Erica. Jeff, I might have a question for you specifically because you are also involved in CAS mediation. And we know that CAS offers mediation proceedings to the potential disputants. I think the last time I checked, they had like 46 mediators on their list as well. Can you give us an insight of how often that process is being used? And why actually FIFA created this shortcut? Because the mediation process was available in CAS, but they decided to create a shortcut and they offer these mediation processes themselves. So what was the problem with using the mediation process in CAS?
Well, the second question's outside of my pay grade, and I don't speak for FIFA. Erica might, so I'll defer to that one to her. I would say that CAS, in its name, is the Court of Arbitration for Sport. It's had, and I think the number of filings, I'd have to look at my last appointed case, but it's up around 10,000 cases that are arbitrations since inception, since it was formed. And the mediation number is a fraction of that, a very small fraction of that. And part of that, I think, owes to the fact that it's an institution in an industry that's heavily dominated by civil law lawyers, and particularly civil law lawyers from a handful of jurisdictions in Europe, where mediation's not taught, where the courts don't really give it much credence or weight, where they don't support it, where there's confusion about what's conciliation versus what is mediation, and the roles of arbitrators or judges in those processes and how they interchange. And just the fact that the industry is very distributive. So people understand winning and losing, even though in football they also understand that a draw gets you a point in some leagues. But they understand winning and losing, and they're willing to take the chance of winning and losing in sport, as opposed to finding what two people can win. That's like a draw, maybe. I don't know. So my views on that are kind of rooted in that. I don't think it's for any lack of effort to try to look at the issue by CAS, but I do think that their primary focus is on arbitrations, and they get year on year almost record numbers in terms of the cases they get. And when you look at their arbitration business in the context of all of the international commercial arbitration institutions in the world, they fall around third or fourth. So CTAC hits number one. I'm a CTAC arbitrator. I'm not sure people believe that all those arbitrations that CTAC claims out of China are actually international arbitrations. The ICDR, which is run by the AAA, usually falls in around second. CTAC's numbers come in around 1,600 to 2,000 filings a year. ICDR is around 1,200 to 1,600 a year, maybe. I'm ballparking this, it changes. And then the ICC comes in at just over 1,000. But it's neck and neck. CAS is neck and neck now with the ICC in terms of arbitration filings annually. That to me is something, like, that is significant. This is all about one narrow industry that relies on the New York Convention to enforce its awards. I would say overall, the arbitral institutions as a whole around the world haven't done a very good job of encouraging mediation. But in CAS's case, there's not been a high adoption of mediation as an avenue. And I think it goes back to those factors that my theory is it goes back to those factors I described. I don't have any empirical evidence for it, but I've been around it enough to think that some of that is the reason. I'll be quiet now, and hopefully we'll hear from Erica or somebody else.
Well, look, if I don't think when we start thinking of that, we thought, because CAS is not doing that, or is not being efficient. It's not really about that. Also, because I do think we need to separate a bit the fact that not everybody can go to CAS, right? It's an expensive proceeding. And we have, as I said, more than 2,000 cases. And apart from club disputes, all the others are free of charge. So the employment-related disputes with players and coaches are free of charge, which means that many of those cases will not reach to CAS, also because the amount, or the parties will not want to go through, because it's a long proceeding and it's an expensive proceeding. So we did think it was important to give the possibility of mediation at that stage, where it's really free access to the sporting the dispute resolution system. I think that's the answer.
Thank you. We have a question from Marcelo Bronstein. The question is, are there in the FIFA list any non-lawyer mediators?
No, in principle, no. If I'm not mistaken, no. But when we look for it, we did say that we're looking for lawyers with experience in mediation, to make sure that we provide the right service for the parties.
Okay.
But I have to say that we keep getting more people applying. So I think we had that question in another webinar we had, and maybe we'll open the list again. But for now, I think we have enough. Let's see how successful mediation gets and how many cases we get per year.
Erica, you also talked about you were surprised by how successful this process has been so far, and Jeff talked about being free, being fast, and being I forgot the third one. What was the third one? Fast,
flexible, fair, flexible, fast, free, and now football specific. There's the other app.
Yeah. So I was wondering if you have a number of how many cases so far have been mediated since the initiation of this process.
No, I do. Look, I might be wrong, but I think so far it has been 6 cases. This has just started, right? So we have recently issued the guidelines, and I think successful, but ongoing right now, I don't know how many there are. I'm talking about the ones where we have actual settlement agreements being concluded or being ratified. But there are several cases, the mediators and online can confirm. There are several cases where mediation is ongoing.
Okay, thank you so much. Roberto, this question might be for you. There's a question again from Marcelo, which says, are there any similar movements in CBF? Like, do we have these mediation proceedings in Brazil, in football disputes in Brazil? And we talked about how dispute resolution in sports are based in the constitution of Brazil and how different it is. So please enlighten us.
That's a really interesting question and a really tough question to answer, in the sense that I'm not entirely sure if I can be direct on my sincere answer. So I'd say that CBF has in its bylaws the provision of mediation. It also has a CBMA clause in it. So I'd say that largely if CBF chooses at some point to develop mediation, CBMA would be the go-to place. And although it doesn't have a specific mediation procedure in place, it has the Brazilian version of trying to make the parties agree on something that we call conciliation within its NDRC procedures, which is the National Dispute Resolution Chamber, that tends to associative cases, or basically cases that tend to transfer issues, player or coach registration issues, and agents issues in Brazil. And I'd say that that's about it for now. I've seen some developments actually in the judiciary regarding sports mediation, specifically in the labor courts. And I'd say that one of the main judges that are actually talking about it is Ana Paula Lockman here in Brazil. And she has quite an interesting work on that specific area. But again, super, super, super niche.
So Faraz, if I could add to that, just not Brazil specific, but globally,
Sure.
Maybe another F word is fancy. Because the dispute resolution we're talking about at this level of football is, if you imagine the developmental pyramid, right? The top is the most elite group of athletes, and the bottom of the pyramid is the grassroots level of everybody trying to become a professional football player. It's the same pyramid in different sports. You name the sport, it's just the same pyramid with different names. You're looking at this process covering the higher end of that pyramid. And yet there's all of this unrequited, unresolved dispute activity going on at a much lower level. I mean, when I was the general counsel of the U.S. Olympic Committee, USA Badminton had one CEO, a secretary, and maybe one other staff member. And yet it produced this inordinate number of dissatisfied people complaining about different things at the grassroots level. And that would take up all of the CEO's time and effort and stuff. So they couldn't go out and raise revenue. They couldn't push the national team agenda and any of that stuff. And so football can't be much different than that on that pyramid spectrum. FIFA's, I think, taking charge of the part it sees toward the top of that pyramid. But at a domestic level, these kinds of dispute resolution processes aren't fancy, really. They're not special. They're applicable across all ranges of disputes. They happen in commercial society every day. Consumer disputes, low-level employment disputes are resolved through mediation and the like. And there's no reason that with enough motivation and effort, governing bodies can't pull together even and realize scale economies in developing a dispute resolution system that solves this lower level of very loud noise of disputes about why isn't my kid on that team, or why didn't you put my kid out, or why is my kid not being, now they're not able to compete in this team over here at this with this other school, and you name it. And it goes on worldwide. So I think that the question that was asked is a very good question, and it's a fundamental question at some level of tremendous philosophical import in sport around the world. So.
Well, thank you, Jeff, for that explanation. I promised Erica that we won't go over an hour. I know that it's late time in Europe. I just want to extend my thanks to all our great speakers that made themselves available to have this webinar. Thanks to our participants as well. Thanks to CBMA for all their efforts in putting together everything here. Thanks to Loyola Law School for being a co-sponsor for this webinar. I hope that our audience have found this discussion helpful. I really enjoyed having all the speakers here. And I hope that we can have more of these type of discussions in the future. Thank you so much, and hope that you guys all have a great time. Thank you.
Thank you very much.
Thank you. Bye.
Thank you very much. Have a nice evening. Bye.